There you have another Jane Doe testifying as to her interaction with defendant Kellen Winslow Jr. We're joined here by another guest, Judge Birmingham. How are you doing today?
I'm doing very, very good. How are you doing?
I can't complain. Now, again, this case seems to be the situation of it cannot be coincidence when there are so many alleged victims. Hearing the interaction that Jane Doe number 5 testified to, it sounds very familiar to the other Jane Does. Would you agree or no?
Well, I think that is the advantage that the prosecutors have in trying a case with 5 different victims, and that is basically if the defense can poke a hole in one of the witnesses' testimony by saying that she has a bad memory or she's got a motive to testify in a certain way, well, that logic may not explain all of the victims testifying about the same thing, and that principle of connective force is proving to be a real problem for the defense.
Francey, if I was a prosecutor in this case, I think my first words would come up and be like, he likes to show off his member, he likes to follow women who are older and maybe believe that they won't be trusted or won't come forward. He seems to have a type and to seem to like when people watch him, and that seems to be the consistent idea in all of this. It seems to be the strongest or one of the strong arguments for the prosecution.
Well, there's no doubt, Brian, and Judge Birmingham's right. This witness is just one of many. And so even if any one of them have a problem, together they are strength in numbers. And that's what the prosecution is focusing on here. And I guarantee you in their closing argument, at least somebody will call him a sexual predator, because what he's doing is preying on women. He's exposing himself to them without their consent. And then it goes all the way to kidnapping and rape, and they're going to call him a very dangerous person. All
right, Mike, we're going to try our best now. The defense, what can be brought up? I know we talked about some potential missing evidence and what may or may not be seen to try to help give reasonable doubt. Is there anything you see when it applies to Jane Doe number 5?
Well, I think one of the things that troubles me from a defense perspective in this is that here we have it appears this is like a gym, like a LA Fitness, an active kind of gym where there are a lot of people around. And, we have a jacuzzi where, it's not in a locker room, it's out in a public space. It's very difficult to believe that in this day and age, there's not some sort of video surveillance, something from a, safety perspective, especially in a jacuzzi. I mean, here you have a 77-year-old woman. You would want to have those kind of surveillance just to protect so nobody gets hurt in there, nobody has a heart attack while in the jacuzzi, something of that nature. And to not have any of that video, that's what I would really use as my strong point in defense as to this Jane Doe.
Yeah. The struggle seems to be here is that the defense has to really drive home to the jury. You've got to consider this one alleged victim at a time. It could very well be that maybe it's a misunderstanding. Judge Birmingham, it appears that the defendant, as the Jane Doe number 5 describes, is on the hip abductor machine where he's able to open his legs and close them to work the inside and outside of his legs. Maybe this is a misunderstanding. Maybe he's fixing himself. Maybe his shorts are riding up too high. Maybe this is all just a 77-year-old woman and a very young man, and they come from different backgrounds, and what she perceives to be crude act is just a young man fixing himself. Maybe that's it.
Yeah, and perhaps those are some of the things that you're going to hear from the defense in their argument to try to explain why this happened, and that's why the incident in the spa becomes very critical to show the jurors what his actions are and how they might reveal what his intentions are. And I think that when you put both of these together, certainly the jurors can take a look at the woman and her demeanor when she was testifying. It doesn't seem as though she was mistaken. She was obviously very shaken about it. And that's something that still makes her uncomfortable today and almost reluctant to tell the story even today. It's almost like you see her wrangling her hands, you hear her shaking in her voice, and that type of demeanor is more consistent with somebody who was victimized as opposed to somebody who made a mistake.
Yeah, and the crazy thing is, and I'm probably from the prosecution, this has supposedly happened when he was out on $2 million bail after all these cases came up. So we're definitely going to probably hear that being driven home on the prosecution's case. We're going to continue to follow this case and others after this break. So a lot of interesting comments we actually have had while we're listening to the defense attorney. Francey, I'll start with you. You had some great insight as to the cross-examination, or maybe lack thereof, as she's asking these questions. What did you see from this cross-examination?
Well, I've taught cross-examination, and it's a skill and an art, and you have to learn that you need to just get in and get out. She hasn't made a single point yet. If you want to be a good cross-examiner, you have to understand that with any particular witness that you need to make points with, you pick your top, I don't know, 3 or 4 if you have that many, and you get out before the witness kills you. And here we saw the witness kill her because he made himself very likable to the jury in telling a joke about people who quit coming into the gym at the end of the week, and now he's got all the credibility that she really needed.
Yeah, Judge Birmingham, whenever I do a cross-examination, I'm always thinking about, and maybe it's a bit of my ego, what's this going to sound like when I read it later in the transcript, when I maybe use it in summation to prove my point? Judge Birmingham, I heard a very muddled cross-examination. I know that you're sitting there as a judge, so you got a kind of like the quarterback, you have the greatest view of the court. What did you hear as you heard this cross-examination?
Well, I heard the defense attorney trying to get at where is the corroboration? And if there's not any corroboration for this interaction, why isn't there? Could there have been? I think that's what she was trying to get at. Was there another witness? Did they even look for another witness? Did they just take this witness's word for what happened? And if not, she's trying to create in the minds of the jurors reasonable doubt. Perhaps it could be done a little more concisely, which I think is kind of why this might be lost a little bit.
So the judge is being very kind about using the words trying. I'm going to not allow you to use the same word, Mike. Is she doing it or is she not?
She's not doing it. Cross-examination is all about preparation. It's all about preparation. I think the formula is for every 10 minutes of cross-examination, you probably need about an hour and a half of preparation. You're going into dangerous waters. You better charter them. And I think Francey makes a great point. Is if you get 3 points out of a cross-examination, you've had a great day at the office. And juries want to hear where you're going. She's not directing the witness to where she needs to go in the point she's making. He's directing him. It's almost like a very almost like freestyling, for lack of a better term. And it's really not going well for the defense. And there's a lot of good points that could be made in this cross-examination, I think, and it could be made quickly, concisely, and really have the juror thinking. When he said about 300 people coming, you know, your argument, so you're telling me this man was masturbating where 300 people could see him, view him, and nobody said anything but this man, correct? That's your point on cross-examination. Short, concise, make your point, next topic.
All right, then we're going to ship you out to California. Maybe you can go help out the defense attorney, because it appears that there'd be some sort of struggling going on, and I agree with you. There are points that are missing, but hopefully we'll see this play out after this break. So I'm hoping I heard this correctly, and Mike, I'll pose this to you. What I heard was that he spoke to the person that worked at the gym, and they didn't know whether or not they were real cameras or dummy cameras in terms of why surveillance wasn't given. My defender instincts or spidey senses popped up and it said, well, isn't it your job as a detective to go in and check that yourself?
Good job, Spider-Man. Absolutely. I mean, first of all, this is Crunch Fitness. You're getting a call from corporate counsel. I doubt very much that they have dummy cameras there to make it look like we're doing security. It's a major corporation. I think the detective dropped the ball on this, and for the defense, I'd hammer on that.
And Francey, I know this is not an investigation case. I know it's not about what the police did or didn't do, but it seems like this might create an element for the defense to hang their hat on. It might not be a winning one, but might be an argument nonetheless.
No, but Brian, you make a great point. I think it almost always is the defense tactic to make the case about what the detectives did or didn't do. I mean, here you're not talking about a forcible rape. You're talking about someone who the prosecution alleges is acting in a sexually deviant way, which makes it more likely he's acted in a sexual deviant way in the past. But it's always an issue when the government does not do its due diligence. And I think you and Mike have an excellent point. It looks like they did not do it on this video issue.
Now, when we have situations like this, Judge Birmingham, I know we still got a bit of the footage in court. I believe one of the Jane Doe's friends is about to take the stand, but I'll ask you this question first. It appears that witness by witness, there seems to be tiny issues with each case. I guess it's a competing stand of, is the growing coincidence of the similarities of all these Jane Does going to override and find him not guilty? Or is the growing faults of the case going to somehow be able to combat that? Again, we have to look at the standard beyond a reasonable doubt. How do you see it as these growing factors kind of move back and forth, Your Honor?
I think that the jurors are going to be wrestling with that very question. inconsistencies about a camera. Well, okay, if this was just a trial about whether this incident happened at Crunch Fitness, well, then maybe that might be reasonable doubt. However, when you have all of these witnesses coming together saying these things, jurors are going to tend to focus on things that are similar, that are not explainable by the other excuses or reasons given by the defense. And that's going to be very, very important in the jurors' minds.
Okay. Now on the stand is a high school friend with Jane Doe number 4, Nicole Edwards. Let's take a listen to what she has to say. So there you have what we call the outcry witness, at least in New York, or the fresh complaint, as I'm learning that they found in New Jersey. Francey, I know that you're signing off with us. It's a pleasure to have you here, but I definitely want to hear from you before we go out. How do you feel this case is going?
Thanks, Brian. It's always great to be with you guys. I think this is a disastrous case for Kellen Winslow. I think he's going to be convicted. The evidence is overwhelming, and witness after witness is telling a similar story, and I think that's devastating.
And thank you very much for that. We'll be back after this on Law&Crime Trial Network.